to the Clifford Gouldson weekly legal scope via the Periscope app. This morning we're talking with Senior Lawyer in our Tax Structures and Planning area, Sheelagh Gray. Sheelagh, perhaps you could tell us initially a little bit about what the Tax Structures and Planning section actually does for our clients.
Certainly. So the areas that we focus on in our section are personal estate planning issues such as preparing of wills, enduring powers of attorney, binding death benefit nominations and similar things for your personal affairs. But we also do business structures, plannings and transfers. We also do pre-business purchase structuring and entity advice. We can assist with companies, trusts and partnership formations. We can help you with intergenerational transfers and family-owned business advice. We also do estate administration, including contested estates, as part of our work.
Okay, so perhaps you could tell us. Sorry, perhaps we'll talk initially about the importance of having a will.
Yeah, so obviously it's really important to have a will that reflects your intentions. Once you pass away, there's nobody alive who would have a better idea of what you want to have happen to your estate than you. So having a will that reflects your intentions, as well as working together with your existing structures and documents to ensure that your assets pass to the beneficiaries that you wish to benefit, is a vital piece of estate planning documentation. There's a number of types of wills, which we can obviously touch on later, but really the actual just having a document itself is a vital piece of your estate planning.
Okay, and so we talked briefly about making sure your assets go to the right people. So it is possible to exclude someone from your will who might have an expectation that they are going to receive something?
Well, look, it is. I guess when you're preparing an estate planning document, you need to carefully consider who your executors are, and then who your beneficiaries are, as well as some other things such as guardians for children. But it is possible to actually set your will up in such a way that your assets go to the people that you wish to benefit, rather than people who you might have benefited during your lifetime, or whom you in fact wish to exclude because of either personal or other reasons.
So for an example for I suppose is where you might have a child that you've gifted a large amount of assets to during their life, and so you have a different amount given to them in their will. You can sort of effectively get away with doing that.
Yeah, certainly. Look, the easiest example is to consider a family where they have one large asset that is their main asset, such as a family farm or a family business, and that one of their children has continued on in that business with the parents. Obviously, the parents' wish is that that child would continue to go on in that business and also receive some benefit for what they have provided to the development of that business over time. So it may be that during the parents' lifetime they have actually started to gift or give control of that business or that land to a child, and that they then have other children that they are aware aren't going to get any of that main asset, and so they need to make provision for them. Obviously, they can do that with a number of obviously they want to ensure there's some fairness across what they do with their children. So they do need to consider what other assets they own, and then how we can gift those assets on their passing, because they may in fact be assets that they continue to require up until death, such as a family home. So there are certain ways that you can either transfer ownership or set in place certain structures or information that can provide a clear instruction to your executors once you've passed away of how you want your estate to pass, and why you may in your will be looking like you are passing different amounts between different children, even though really there's just some fairness with respect to a child that has previously received something during your lifetime. So
okay, so obviously with estate planning, it's it's important to get your will right, but there are documents involved there other than just your will. And an enduring power of attorney is one of those people often talk about. Can you tell us a little bit about why that document's important or how you might use it?
Certainly. Enduring power of attorney is a document that actually appoints people who are called your attorneys to make decisions for you while you're alive but no longer capable of making your own decisions. So that might be because you have lost capacity due to an accident and you have an acquired brain injury, or it might be that you, from old age, start to suffer from other illnesses such as dementia or something like that, and you're no longer capable of making your own decisions. This document appoints the people that you would like to make decisions for you with respect to your financial matters, but also your personal and health matters. So obviously you appoint someone who will then make all of the legal decisions for you that you otherwise would have made. It's a document that gives quite a lot of power to the people that you appoint as your attorney, so you must always appoint people who you trust implicitly to make the best decisions on your behalf. But from a estate planning perspective, and certainly from a decision perspective while you're alive, it's very important that you actually do have that document in place so that you can be aware of who will make those decisions for you, and that you believe that those people would be able to make adequate decisions on your behalf.
All right, that sounds good. Before we wrap up, we just had one question from a viewer asking about the cost of wills. So perhaps you just give us a rough indication for, say, a couple getting perhaps standard wills, and then also maybe a couple, husband and wife, getting a more complex testamentary trust type will.
Yeah, so what's been hinted at there is that there are actually different types of wills that can be used depending upon what your circumstances require, and also the circumstances of your beneficiary. So for a standard will with an enduring power of attorney for a couple, our prices start at around about $880, including GST. It does depend a little bit upon the complexity of your circumstances as to whether or not that would be appropriate for you, but that's, I guess, something that needs to be discussed and considered when we meet. However, if you do need something a lot more complex, or you have beneficiaries that require their money to be protected, then testamentary trust wills are a very, very useful tool, and you're looking there at approximately $2,200, including GST, for testamentary trust wills for a couple and enduring powers of attorney as well.
Okay, thank you very much. Just a reminder, if anybody has any questions on issues relating to tax structures and planning, estate planning, business structures, etc., by all means get in touch with a member of our team here at Clifford Gouldson. And also a reminder, these legal scopes are on each Friday at 9:45 Australian Eastern Standard Time, if you'd like to join in live. Otherwise, you can find them on the Clifford Gouldson YouTube channel. Just search on YouTube for Clifford Gouldson Lawyers. Thank you again, Sheelagh. We'll finish off there and look forward to seeing people again next week.